Here's the 30-second lesson on what legends know. Never practice nunchucks in a crowded room. Never eat chole before a road trip. Always take your shirt off before you iron it. Don't take a call near a swimming pool. And don't forget, saving is not investing. Legends don't just save, they invest in mutual funds. Mutual fund investments are subject to market risks. Read all scheme-related documents carefully.
A landmark order has come from Supreme Court today, and you know what? It's not even a final order, it's an interim order. This is the three-judge bench led by Chief Justice Sanjiv Khanna with Justice Sanjay Kumar, Justice K.V. Vishwanathan, who's also one of the senior judges. So three of them have given an interim order. Now, what better can I do than to just read a line from this interim order, which basically says, and I quote, effective interim would mean that there will be no order for a survey. What this means is that in many places in the country, people have been going demanding surveys of religious places, mostly, in fact, entirely Muslim places of worship, where Hindu complainants have been going to court saying that this used to be a Hindu place of worship, and this was then demolished or taken over or built over or converted into a Muslim place of worship. 11 of these cases are pending. This started, as you know, with Ayodhya. When it started with Ayodhya, as Ayodhya was building up, the Narasimha Rao government in 1991 summer, Narasimha Rao government came to power. The Congress party in its manifesto then had promised the Places of Worship Act, saying that from here on, there will be protection on all places of worship except the one ongoing case which will be determined in the course of time. That was the ongoing Ayodhya dispute. Now, this law was passed. It was presumed after that this law protects all other places of worship except Ayodhya, and the character of no other can be changed now. However, an order came in 2022 from the High Court in Allahabad, and then the Supreme Court sort of not directly endorsing it, but not interfering in it, which allowed a survey of the Gyanvapi mosque in Varanasi, which is linked to the Kashi Vishwanath temple. After that, similar orders were given, say in the case of Ayodhya, the Krishan Janmabhoomi Shahi Jama Masjid case, and also then Kamal Maula Mosque / Bhojshala in Dhar in Madhya Pradesh as well. And there were several other suits pending, the latest being in Sambhal, where a local court gave an order and immediately ordered a survey the same day, and that led to riots and the death of 5 young people, in this case all 5 young Muslims, gunshot injuries. Now after that, another petition was filed in Ajmer Sharif, and looked like there was going to be a rash of these. It was around this time that the Supreme Court, which had been sitting on the challenge to Places of Worship Act. Now, many Hindu groups challenged the Places of Worship Act, saying that this is discriminatory, that this cutoff date of 15th August 1947, which means when India became independent. So the spirit of the law was, छोड़ो कल की बातें, कल की बात पुरानी, नए दौर से लिखेंगे, फिर से नई कहानी, हम हिंदुस्तानी, आपको गाना याद है ना? So that was the spirit, that 15th August 1947, this is a new India, it's a new republic. So this is a new beginning. And from this point, everything is frozen. Ayodhya wasn't frozen because that was an ongoing legal dispute from the mid-19th century. That is how old that property suit was. It was being fought as a property suit. That said, the Hindu side said that because of this law, this was an arbitrary law. The BJP did not vote for the law, as you would expect. This was Mr. Advani's BJP at that time. Instead, he used the spark of this law, the enactment of this law, to further light up the fuel for his Ayodhya movement. And that's when the Rath Yatra and all other developments took place, leading up to the demolition of Babri Masjid just over a year later in 1992, December. Now, this law had been set by the Supreme Court itself in its Ayodhya judgment, the 5-judge order in the Ayodhya judgment. This law had been set, it had been placed in the core of the secular structure of the Constitution, and thereby this law had been given the protection of being reflective of the basic structure of the Constitution. The logic being, since this law was enacted to protect secularism, I'll read a line or two from that judgment. And secularism is a part of the basic structure of the constitution. This law cannot be messed with. So that is what happened then. The Hindu side challenged this law in the Supreme Court, and this had been pending for quite some time. Now Supreme Court has decided to take it up, although this Chief Justice's tenure is just over 6 months. It's a short tenure, but he's been bold enough to take this up now so as not to kick this can down the road, because what's been happening is that because this question has remained open, more and more courts, particularly at lower levels, are saying, look, there is a challenge to the Places of Worship Act pending. So until then, you can allow at least surveys or research or finding or fact finding of these places of worship that the Hindu side, mostly it's Hindu versus Muslim, the Hindu side is talking about. Now, from where does that come? That comes also from the fact that in the earlier order, in the Gyanvapi order, the High Court said, and the Supreme Court also indicated, that because the 1991 Places of Worship Act is under challenge and the Supreme Court has not taken a final view on this, you can still carry on under the umbrella of this protective umbrella of this being under challenge. That because the final status of the law is not clear, meanwhile you can carry out some activity by way of fact finding. Now, what's happened today? What's happened today? Let me tell you that, and then I will also tell you the root of the current problem. And that's one of the reasons that Justice D.Y. Chandrachud, the outgoing Chief Justice, has got such bad press from so many of his critics. In fact, not just his critics, but also many eminent lawyers as well. Now, what is it that the judges have said today? Number one, they have said that no court where any of these cases is going on right now will issue any further orders, either interim or final, which means if you want to hold hearings, give dates, that can carry on, but nobody can give any orders, either interim orders or final orders. So effectively, this means a stay in all proceedings. Second, they've said that new suits, people want to file new suits. Somebody said they'll file a suit on Jama Masjid of Delhi. You can file a suit on anything because it's a civil suit. You can go to court and file. They've said that while you might go and file any suits, but no court will number any of the suits. What that means is that the court proceedings, the suits will not be admitted for any process. So no court will start any process on these suits. You can keep on filing if you so wish. Effectively, this means now that there is a standstill on all such activity, or footballing terms or hockey terms or wrestling or boxing terms, it's a timeout. Referee blows the whistle and says the game stops for now. That is what has happened now, while the Supreme Court fast forwards the hearing of the Places of Worship Act. In fact, they've given the central government 2 weeks now to file its own affidavit, and it will be interesting to see what will the central government say, because remember, the BJP had not supported this law. This is essentially a BJP government, but it also has coalition partners who claim to be secular parties. Nevertheless, how convenient is it going to be for a government, for an elected government, to go against a law which has been passed and which has gone through the tenure now of so many governments, including two full BJP governments, full majority BJP governments under Narendra Modi, for them to say that they don't agree with this law, while the same law has been posited within the basic structure of Indian Constitution by this Supreme Court. So that is the interesting thing to watch. However, today's orders have called a timeout on all ongoing processes. So for at least some time, these headlines will now cease. This mosque, this Eidgah, this temple, that something, all of that will cease for now. Now, what is this that started all of this? All of this started with an oral observation by Justice D.Y. Chandrachud in the Gyanvapi mosque case in Varanasi that we've spoken about in detail in an earlier Kattak letter as well. What did he say? Please listen to his words. What he said was, and I quote, "The ascertainment of a religious character of a place as a processual instrument may not necessarily fall foul of section 3 and 4 of the Act. Now, processual is a word that I've heard for the first time today. In fact, we checked and we found that this actually exists. But judiciary, you can trust them to find these things. In fact, I think I mentioned this to you earlier, but Arun Shourie once told me that he had gone to meet Justice V.R. Krishna Iyer for the simple reason that he wanted to tell him that People's Union of Civil Liberties wanted to give him an award, right? And he found that he was sitting with his stenographer and he was writing a para in his judgment and he found a couple of things to say and they were easy words and he said, no, let me find something more interesting. So he opened the thesaurus and he found more difficult words to use in place of the easy ones. So much before Shashi Tharoor came the Indian judiciary, and Shashi Tharoor is only one in Indian judiciary. There will always be a judge who will figure out, who will find some word that you've never heard before. So processual is this word. What this means is that there is nothing in the Act that Places of Worship Act bars you from changing the character of any religious place, but it doesn't bar you from the process of checking out what this was. And can you imagine the implications of that? Because if you carry out quote unquote surveys over these places and then say, I found a little bit of this, I found a little bit of that. And the fact is that India has a complex history, particularly medieval centuries. India has a very complicated history and very rough history. So if you started opening all of that up, and these surveys will open all of that up. So can you open all of that up and then still maintain the letter and spirit, both letter and spirit of Places of Worship Act? So that is the reason Justice Chandrachud is getting so much criticism, that by just this one oral statement, verbal statement, what's happened is, as a result of this, lower courts, high courts, trial courts across the country have latched onto this one statement because it was spoken by the Chief Justice of India. That's why it's always said our parents, our grandparents, and I'm sure their parents and their grandparents all told them that be careful, zaman pe lagam, don't talk too much, because what you say today, you may be well-meaning, however well-meaning you might be, but what you say today, if it is indiscreet, it may come back to bite not you. If not you, then other generations, which is what's happening in this case. And that is something, those are the troubled waters on which this three-judge bench today has quietly poured some oil to quieten things down. It doesn't mean the politics over this will die, but this will at least quieten things down for now until a final call is taken on Places of Worship Act. I told you the Ayodhya judgment, where the five-judge bench actually positioned the Places of Worship Act in the basic structure of the Constitution as linked to secularism. And I will read some lines from there, and then you can figure out how important this interpretation of the law is and what is it that is under challenge in the Supreme Court before the Places of Worship Act bench now. And I quote from the Ayodhya judgment, the state has, by enacting the law, that is Places of Worship Act, the state has, by enacting the law, enforced a constitutional commitment and operationalized its constitutional obligations to uphold the equality of all religions and secularism, which is a part of the basic features of the Constitution. And then it says, the Places of Worship Act imposes a non-derogable obligation, जिसको change नहीं कर सकते, non-derogable obligation towards enforcing our commitment to secularism under the Indian Constitution. The law is hence a legislative instrument designed to protect the secular features of Indian polity, which is one of the basic features of the Constitution. Non-retrogression, which means what's been given, the protection that the law is given today cannot be withdrawn, which means protection that the law and Constitution have given you today cannot be withdrawn. Non-retrogression, retrospective or retrograde. So non-retrogression is a foundational feature of the fundamental constitutional principles of which secularism is a core component. The Places of Worship Act is thus a legislative intervention which preserves non-retrogression as an essential feature of our secular values. Non-retrogression means not taking back the protections which have already been given, or once again, if I may put it in simple words of the poet, छोड़ो कल की बातें, कल की बात पुरानी. You can't go back to them. Again, that order goes on to say, and I'm deliberately underlining this, that Places of Worship Act is, and I'm quoting from the order, intrinsically related to the obligations of a secular state. It reflects the commitment of India to the equality of all religions. Above all, the Places of Worship Act is an affirmation of the solemn duty which was cast upon the state to preserve and protect the equality of all faiths as an essential constitutional value, a norm which has the status of being a basic feature of the Constitution. So this is quite ambiguous. And this is under challenge. Now, while this has been under challenge, all of these other cases have come up, and all of that has been triggered by that one unfortunate, I would call it, unfortunate remark by Justice T.Y. Chandrachud, and that's a verbal remark. And see the cases that are going on right now. It's a list that Bhadra Sinha, our editor for legal affairs, sent to me. Gyanvapi Mosque at Varanasi in Uttar Pradesh, Shahi Eidgah Masjid at Mathura, Jama Masjid at Sambhal, where the riots took place just now, TK Wali Masjid, Lucknow, Jami Masjid and Dargah of Sheikh Salim Chishti at Fatehpur Sikri, then Atala Masjid in Jaunpur, Shamshi Masjid in Badaयूं, again in western UP, Quwwatul Islam Mosque at Qutub Minar in New Delhi, in fact in South Delhi, Kamal Maula Mosque and Bhoshala Complex in Dhar in Madhya Pradesh, Ajmer Sharif Dargah that we've been hearing about very recently, and Juma Masjid Mangaluru and Malali Mosque. So all of these are ongoing, and if the courts had not stopped the process today, this would have gone up like a T20 score because so many of these were coming up. And finally, since we are talking about oral observations, while delivering this interim order, another oral observation was made, and that's important, by Justice K.V. Vishwanathan, who is also a senior judge, in fact, in line to be CJI in some time from now, in August 2030. And I'm quoting from Justice Vishwanathan now. He says Section 3, which is the section of the Places of Worship Act, which bars the altering of the character of any place of worship as it existed on 15th of August 1947. He says Section 3, one view is that it is only an effective manifestation of or a reiteration of the already embedded constitutional principles, so much so that even without the Act, that is Places of Worship Act, even without the Act, if a suit were to be objected on the ground of plain constitutional principles, an argument may arise on Order 7, Rule 11D. When that is engaging the attention, and when you have a judgment of 5 judges, the Ayodhya judgment, when you have the judgment of 5 judges setting out certain principles, civil courts cannot run a race with the Supreme Court. As simple as this. So this is as emphatic as that. And just as I was about to finish, word comes now, and that's the reason you see the smile on my face, that Gukesh has now become the world chess champion. So something for us to celebrate after rowing over some serial disasters in cricket. This is fantastic news. And we had already told you that India is now building such a huge depth and width in chess talent. India is producing more grandmasters, for men as well as women, than any country in the world. In fact, we had featured this in a full Katta Clutter just the other day. I will share the link with you again. So please do check it out. And I'm sure we all have agreement at least on one thing, that this is something that all Indians should celebrate. A World Chess Championship in a traditional sport where India is now dominating the entire world. The Russians, the Americans, all of them have been, I would not say swept away, but all of them have been left behind at this point of time.